DJ MUTHOGA, who approved the idea of an inn of court. Starting, this is how busy we are. You can see we are working on as we go. We are working on the CTS. That is how busy we are kept by our litigants. Let me just pull the slides. Yes. My site is... and have you noted there's a problem with CTS today? Yes, all this you can see trying to load. We have been trying to work on them, but it is not allowing us to do that. So, sorry, that is for law students another day. Yes, now I think I have the correct one. And we show from the beginning. Full slide. Let me see whether I can enlarge this one. Where is help from the... I'm trying to get it enlarged. I'm thinking it should be bigger than that. That's what we have? That would be the whole screen. So the idea of inns of court is an opportunity for a common room discussion of law by experts in the bar and on the bench. We meet as a bar bench organization where we discuss issues of law, common legal problems that arise, problematic principles of practice, and we end up discussing issues in a friendly way, safe distance, not anybody representing any party, but in a way that you donate your expertise and time to reflect on a common problem. And that inn of court idea brings us together, and I have given you a picture there of a common room. A common room as you would have in the university, where lecturers of a faculty will meet in the evening to discuss. So we are supposed to be as free as you can be at a common room to discuss without strictures of what corner of profession you are working from, the bar, the bench, the corporate world. So long as you are a lawyer, or in some cases we admit law students also, and you are able to reflect on the problems. So I pulled out where the whole idea began. In England and Wales, where we have the 4 inns of court, through which barristers qualify, they are trained and instructed in the practice of law. As you can see, we of course have some similar organizations in Ireland and also in Scotland, but on England and Wales, we have the 4 of Grays, Lincolns, inner and middle. Almost every other person you would meet there, he would be in one of those. And in the old days, it used to be that you would even be housed at your inn, and you would have your chambers at the inn. But as you will see, and this one is just a pull out from Wikipedia, you can pull that one out. You will see because of numbers and space, now people are getting chambers outside the temples. When you have opportunity to go to England, you can ask that you visit one of the inns. So the inn is an idea that brings people together. Here, they would train you and instruct you in the practice of law, and you qualify as a barrister. For us, we have, of course, other methods of the LSK and the CLE, School of Law, for qualification. So this idea, it was carried across the seas to America. And in America, we have Chief Justice Warren from 1970s. The idea only coming to fruition in the 80s, proposing that we would have a similar organization of inns of court, now ported into America. And his idea, which our inns of court idea is based on, is that we will have inns. You can see that they're loosely modeled on traditional English inns. And in 1985, that's when he was able to start the American Inns of Court Foundation. And they across the states, and each local inn is devoted to promoting professionalism, ethics, legal skills amongst American bench and bar. Of course, in England also, we have benchers of an inn. When you have been a QC, a barrister, and now appointed as a judge, you retain your inn, but you are now a bencher of the Lincoln's Inn or Gray's Inn or whatever inn it is. So in America, it involves both bar and bench. And this is a model from which our own Kenya Inns of Court is derived and based. And what we try to do is, see loading here, that we have one Kenya Inns of Court, Central Resource Center. Then as to, you have seen it is loading, let me just do that manually. You can see that we have the Inns of Court, which is a global composite body of court Kenya. But they are modeled according to where we have sufficient numbers of practitioners and judges. So that if Kirinyaga County now has the number of judges, the number of magistrates, and sufficient number of practicing lawyers, you can form an inn of court from where you would have your proceedings as we go. We started in 2012 with Mombasa Inn of Court, 2012. And I know that the commercial division of Nairobi also started their own, so I call it Nairobi Inns of Court. Then thirdly, I say that we now have Kerugoya Inn of Court, because this is the third Inn of Court that I have learned has started business. There has been proposals by the Judge Byram of the Industrial Court to start his own, but I have not heard that it has kicked off. So I can just then expect that the others will pick it up. Randomly, I say Kakamega may come in, Kisii Inn of Court, Nyeri, Meru, Kisumu Inn of Court. As we go, Eldoret Inn, Nakuru Inn, Machakos Inn of Court, Inn of the Industrial Court, and finally Inn of the Environment and Land Court. These ones are not there. This is just a vision that we expect them to do. But we expect that they will be gathered around the towns, the high court stations, court of appeal stations, where there is a sizable number of legal practitioners who can form themselves into an inn. That is what we hope Kenya Inns of Court will look like when it is finally developed. When all these regional inns come together, between themselves they may share to consider questions of law affecting their regions. They are linked to the center organization which is coordinating all of them. And inter se, they can also hold joint sessions. The central one, the main inn of court body, will coordinate the activities of that. The relevance for that today is that, and I also wanted to say that in 2013, we started a publication called Lessons in Judicial Practice. In fact, MUTHOGA wrote an article there in Techniques of Effective Judgment Writing. It is covered here. And I wanted to show you how this capture here was done. There is a discussion of Kenya Inns of Court in a chapter here. We will see whether we can get sufficient copies through Mr. Ngige Chair to circulate to members. And then they will be able to read in detail how the Inns of Court is supposed to operate. It is totally free, voluntary organization. In Mombasa, we started with a declaration of intent, and then members made rules how to run the program. But it will be free for any organization to decide where, when to meet, and the modalities of that. Relevance to today's occasion, I wanted to point out that our presenter, MUTHOGA, I didn't know that he would bring a copy of the book. I had my own copy because I was fortunate to attend the launch. And I wanted to read for you a passage from the book which will show that the man is suited to be here this afternoon. He says about his life in the University of East Africa at Dar es Salaam, at page 41 of this book, I maintained an active life at the university. I was the chairman of the university's debating club and the Denning Law Society. You have heard of the Denning Law Society? You have the chair of 1966, I think it was, right here, which discussed topical legal issues. I also served as editor-in-chief of the society's law journal. And then he says, I partied and socialized with my fellow students, and we engaged in a few youthful indiscretions. If you read the book, you'll see what indiscretions there were. We would venture into town center on foot or board a Dar es Salaam motor transport DMT bus with no money to pay the bus fare. These buses had 2 access doors, one at the front, one at the back, so we could play hide and seek with the conductor. And as he inspected the bus tickets, we ran out from the other side. So that's an interesting passage I saw when I was reading the book. But I wanted to highlight that the presenter today was chairman of the university's debating club and chair of the Denning, Lord Denning Law Society of the University of East Africa at Dar es Salaam. So he is most suited to make this presentation. And you can see that though they did not call it an inn of court, it is something they have talked about under the name Denning Law Society at the time. So having demonstrated what the Inns of Court idea is about, we can have other occasions to deal with this and refine the idea. It has been 10 years now, but it can still be improved as others pick it up. I should like to rest it there so that we give time to the presenter to make his case and for our plenary discussions thereafter. Thank you very much.
We'll now invite Justice Mutungi to invite our guest. Karibu, Judge.
I chose to use this one. Good afternoon. Yes, I'm quite sure that most of you know me. And those who do not know me, my name is John Mutungi of the Environment and Land Court here at Kerugoya, but with the extended jurisdiction in the Northeastern Province. I have been requested to introduce and invite my former partner, Judge MUTHOGA, to speak to us. And before I do that introduction, I have to let you know, 45 years ago, I was Judge MUTHOGA's pupil in July 1979. I joined the law firm of MUTHOGA, Gaturu and Company Advocates as a pupil. I was referred by Gibson Kamau Kuria with a complimentary, and I walked into Judge MUTHOGA's office then. He was a young man then. I was almost a boy. Yeah? He didn't ask me many questions, but he offered me pupillage in 1979. In July of 1980, I joined the Attorney General's office as a state counsel, only to see Judge MUTHOGA in 1981, February. He came to look for me. I was quite a tiny person. He told me, can you come and work with us? What I did not know is that Judge MUTHOGA was then setting me up, because it was in February 1981, and in March of 1981, I was taken to Nyamakema in Nairobi and told this matatu stops at T4 Nyahururu. So, and I was told in Nyahururu you'll find a new building of KCB Bank. That is where the office of MUTHOGA Gaturu Rift Valley branch was. So, being the obedient person I was, I entered the matatu and walked into KCB upstairs, and I found an office. Then I was the managing director there in that office. Yeah. Then soon thereafter, of course, Mr. MUTHOGA, he was then our managing partner in the law firm. Soon thereafter, I told him, now this place is too cold. That was Nyahururu. Those of you who know where Nyahururu is know what I'm talking about. But then He's a sweet talker. He told me, no problem, we will sort this out. So again, in 1982, I was back in the city, only to go back again in 1983, up to 1991. I was the managing director of those signs. Why am I giving that story? Before you is a very resilient person, and a person who I've known for all those years. I know is the way he used to prepare his briefs. If you are a lawyer in that law firm, and Muledi was some time, when Judge MUTHOGA and a preparation to do for the Court of Appeal, the whole office was at his beck and call, and nobody would sleep until around 10 to preparing. I wonder whether we prepare our briefs the way they ought to be prepared. This is the man who should let you know how that is done. But he's coming to talk to us about succession as configured by Judge Muredi to start the Inns of Court. I know him as a person who has done so much work in succession matters, including of his own father, of which I was the executor. So, but there is one he started in 1981, I'm sure you mentioned it, which he has not completed. You hopefully let us know why and how it can be done. But otherwise, he is a person who most of you would love to have the zeal that he had. When he was appointed to serve at the ICTR in 2003, for some reason, he left the firm, and I was the managing partner of that firm, and I can tell you that firm is still alive. In fact, on the 14th of June this year, they celebrated their 50th birthday, and I'm sure Judge MUTHOGA was there, but for myself and Judge Muredi, Judge Muredi and organized other activities which I could not miss. So, Judge MUTHOGA, we offer you our congratulations. You sustained a law firm, which, as I know, you said was to rival the Hamilton, Allison, and Matthews, and the Kaplan and Strachan of this world. And I think you did your bit, and you can give us a few tips on how to do some of these things. And I'm sure the people in this room, and the practitioners, I'm so happy to see so many of you who benefit from your wisdom and your way of doing things. So I will ask us to put our hands together to welcome Judge MUTHOGA to speak to us. The G is Gashoiga. Gashoiga MUTHOGA, for those people who might want to know what the G stands for. So, Judge MUTHOGA, you can come and talk to us. And thank you very much for making the effort to be with us today.
Very much, Judge Mutungi. And before I start, karibu sana Judge and our discussant. I'll be inviting Honorable Martha Opanga from the Wanguru Law Court to read for us the bio for our chief guest. Karibu.
A very good afternoon to all of us. My name is Martha Opanga, as you have been told. I'm a magistrate. I serve at Wanguru Law Court. I have the privilege and honor to read the biography of our chief guest today. I thought that Honorable Justice Mutungi had given us part of it, and I thought we had passed that step. Be it as it may, I will read the biography of our chief guest. Judge Lee G. MUTHOGA was born in the year 1945 under a mugumo tree, they say, in the rural village of Munyange in central Kenya. And they say that perhaps his birth under that tree has turned out to be a prophecy of the resilience that Justice Mutungi was talking about in life. He has had to face life and the magnitude of it in a hard way and has made great contributions and beyond, in Kenya and beyond. He has a bachelor's degree in law from the University of East Africa in Dar es Salaam and has practiced law for 32 years, I suppose, and over. He served as the chairman of the Law Society of Kenya in the years 1981 and 1983, and the president of the African Bar Association in the year 1981 to 1987. In the year 1986, he was appointed a commissioner of assize, serving in that capacity for 10 years. In the year 2003, the late President Mwai Kibaki conferred upon him the rank and dignity of senior counsel, and in the year 2006, he was named to the role of honor of the Law Society of Kenya. He is also a fellow of the Chartered Institute of Arbitrators and fellow of the Institute of Certified Public Secretaries of Kenya, now the Institute of Certified Secretaries. Between the years 2003 and 2012, Judge MUTHOGA served as an ad litem judge of the United Nations International Criminal Tribunal for Rwanda. And in the year 2012, he was elected as a judge of the United Nations Residual Mechanism for International Criminal Tribunals, where he still serves to date. To expand access to justice, Judge MUTHOGA is involved in mediation and training of mediators as the chairman of Dispute and Conflict Resolution International. Currently, he resides in Nairobi, Kenya, and enjoys spending time with his daughters, telling tales to his grandchildren and attending his avocado and tea farms and supporting community-centered philanthropic initiatives. How many of us can do that? We appreciate him and we applaud him as we invite him to speak to us. We can do an Obama clap again.
Thank you very much, Honorable Martha. At this time, because of interest of time, I'll also invite Jane Como from the Office of the ODPP to read the bio of our discussant, Mr. David.
Thank you, Honorable Claire. My name's Jane Como. I'm a prosecution counsel based at the office of the DPP. I am privileged to read the bio of David Njuguna Njoroge, who is one of the discussants. David Njuguna Njoroge, a fellow of the Chartered Institute of Arbitrators, CPM, CS, is a holder of a Masters of Law, LLM in International Dispute Resolution from Queen Mary University of London, Bachelors of Law, LLB from Makerere University, and a postgraduate diploma in law from the Kenya School of Law. He is an advocate of the High Court of Kenya of 15 years in good standing, an arbitrator fellow of the Chartered Institute of Arbitrators, MEC accredited certified professional mediator, and a certified secretary by CASNEB. Vocational call. David is the senior partner and head of the dispute resolution at Njuguna and Njuguna Company Advocates, a boutique law firm based in Embu. He's an adjunct lecturer at the University of Embu School of Law. He's an approved tutor of the Chartered Institute of Arbitrators and a pre-qualified ADR tutor at Nairobi Center for International Arbitration. David was elected by peer ADR practitioners to the board of directors of the Chartered Institute of Arbitrators, Kenya in 2024. In the year 2025, fellow directors elected him to the high office of the Vice Chairman of the Chartered Institute of Arbitrators, Kenya. Service to the nation. David is serving the judiciary as a member of the National Environment Tribunal, member of the National Steering Committee for the implementation of the ADR, Alternative Justice System Policy. He has served as a member of the State Corporation Appeals Tribunal, the National Steering Committee for the formulation of the Alternative Dispute Resolution. He is a chairman of the Embu County Court Accredited Mediators. He has a special interest in ADR, AJS generally, and its growth and development in the country as the most ideal mechanism of dispute resolution and social transformation in the society. Service to the bar. David has served as a council member of the Law Society of Kenya, 2018 to 2020, where he was the convener of the ADR committee. In November 2016, he was elected among the 3 Kenyan council members to the governing council of the East African Law Society and served it in Young Lawyers Committee. In February 2016, he was elected as a council member of the LSK 2016 to 2018, where he was the convener of the Young Lawyers Committee. Further, he has previously served as a council member of the Mount Kenya Law Society in 2014 to 2016, a branch of the LSK. Accolades. Among others, David has been awarded certificates of recognition for being the ADR Practitioner of the Year 2024 by the LSK Mount Kenya branch, listed among the next litigation hall of fame in Kenya 2025. Top 100 litigation lawyers in Kenya 2024, and top 100 arbitrators in Kenya 2023 by peer organization, the Lawyer Africa, a leader in legal news, profiles and insights in Africa. Interlude. David is an avid golfer and the inaugural captain of Embu Golf Club. Benevolence. He's a committed Rotarian and an award-winning past president of the Rotary Club of Embu. Kinsfolk. He is married to one beautiful wife, and they have an adorable baby girl. Thank you. We can clap for him.
Thank you very much, Jean. So at this moment, Honorable Justice Lee MUTHOGA, this is the moment we've been waiting for. We are yearning and ready to hear what you have for us. We are ready to learn. And I believe at the end of the presentation to the plenary, we'll have so many questions, and we believe that you'll be able to answer us. Karibuni sana.
Ladies and gentlemen, I've asked to present this while seated, because as I told you, I have one of my legs which is not being very kind, it's not cooperating. And I have 100 and something kilometers to do after this. But you see, that then brings rise to two problems. One of them is that I will try to speak to myself, and people at the back may not hear me. So I would wish that if you cannot hear what I'm saying, you have the courage to put up your hand and say, I can't hear, so that then I will then amplify the volume, and we can all hear. Let me ask the question then. Is there anyone now who can't hear what I'm saying? I don't know how I can prove that or not prove it. Those at the back, Sam and colleague, can you hear me? If you can, raise up your hand. Okay, good. It means that there's a voice up there. The next thing is this, that I will probably disappoint you, because I've heard from those introducing me and introducing the subject, I feel shy about the presentation I'm just about to make. I lack the courage to just tear it off, and so I'll have to survive with making it as it is, and hopefully leave enough time for you to really ask me the questions you wanted me to answer. Because I almost certainly know that my presentation will not answer those questions. But we'll put a time at the back, and you ask those questions, and to the extent that I can, I will answer them. So let's be fair on that. I was given a topic. Underline the word given. I didn't ask for it. I was given a topic to address, and it was looking for effective ways to determine and ending inheritance disputes, the space of ADR. That is the topic I was given. And who was given that topic is me, and I'm a judge of the mechanism for international criminal tribunals. I've detailed out, I think it has been detailed out by those in my biography, but if you allow me, I will just read it out as I would have liked it to be read out. That my name is Judge Lee MUTHOGA, and I'm a judge of the United Nations Mechanism for International Criminal Tribunals, which, as many of you know, is the successor in title to the International Criminal Tribunal for Rwanda and the United Nations, and which the United Nations set up in the last decade of the last century, along with the United Nations International Criminal Tribunal for former Yugoslavia. These two tribunals were wound up. The member states of the United Nations felt that they were spending too much money in maintaining these tribunals, or so I heard, and therefore decided they must be wound up. But you know, winding up a court is not an easy matter, because decisions that courts make have long-lasting repercussions. You have people who have been sent to prison, they are serving their 20, 30, 40 years terms. They will need something, they will need to ask of somebody. And because it's not a state court, it's a United Nations court, you can't just wind it up. So they decided to establish a mechanism, a roster of judges, 25 judges in all, 2 from Tanzania and 1 from each of the other 24 states. The UN, as you know, is a body that is careful to ensure that it's as spread out as possible. So you wouldn't be allowed to have several Kenyan judges or several Ugandan judges or several judges from the Netherlands or from UK and so forth. The only country that was made an exception is the United Republic of Tanzania, which has 2 slots. And it justified the second slot by reason of the fact that it had hosted the tribunal for a long time. So those judges are charged with trying those who were thought to be primarily responsible for the genocides which occurred in Rwanda and former Yugoslavia. And in the United Nations Tribunal for Rwanda, we indicted 91 people. In the United Nations Tribunal for former Yugoslavia, they indicted 201 people. Now, all these people have now been tried, except one person who is called Felician Kaboga. You probably have heard of Felician Kaboga. He was sometime a refugee, a fugitive hiding in Kenya, but was eventually arrested hiding in France in the year 2021. He was arraigned in court, and it then became apparent that his dementia had advanced so far that he was not able to respond to the issues that were before him. And so he was found unfit to stand trial. And therefore, because he is in our hearts, we are holding him in the United Nations detention facility at The Hague. He's the only one, he's the only person we have. We cook for him, we have a doctor for him, we have a cleaner for him, we take him out to the fields to exercise, and we do all those things for him in a facility built for 216 people. He's the only one we have. But we can't do anything about it because we can't acquit him because he has not been tried, and we can't convict him because he has not been tried. So we are holding him, and we have asked our president to go back to the Security Council and ask them how long they want to run the place with only one inmate. Now there are problems why he can't get that, because countries don't want him. France, where he was caught, does not want to touch him. Belgium, where his people are, will not touch him. The European countries, all of them will not touch him. He would not go to Rwanda, which would want to have him. And so we are looking for countries in South America and other places, and we have not been able to succeed. So we continue serving. My term expires on the 30th of May 2026. So God willing, I should hang around for that period and do what we call remedy work that was not done by the tribunals, or work that arises as the tribunal goes on. We have prisoners in Mali and Burkina Faso, and we have prisoners in Italy and the Netherlands and England. No, we don't have in England. No, that's. But we have in Belgium and in Norway, I think. Those, they are coming out, of course, they are finishing their terms as we go on, and when we finish, they go. And we hope that soon enough, most of them would have finished their terms and gone, and then the institution can be closed. So I told you the topic that I was given to talk to, and I think now it's about time I began talking about that. The topic that I was given, that is looking for effective ways to determine and ending inheritance disputes, the space of India makes two assumptions. One, that the present way of determining inheritance disputes is ineffective, i.e., is not effective, meaning is without effect, and the disputes are an ending. That's the assumption the topic makes. It makes the assumption that there are some way of dissolving them which is not effective and which does not end them. It's an ending. So it puts us held in a clutch there. We'll find something that will undo that. The next assumption it makes is that there must be another way to determine them, which is effective and brings the inheritance disputes to an end. That is, it resolves them. Because they can only come to an end when they are finally resolved. Now, these two assumptions make the fundamental basis of my lecture today. What I talk to you about now will be really founded on finding whether there is, in fact, a way of resolving disputes which does resolve them finally. And let me say what I have said in other ones, that we are engaged in an inquiry whether there exists another way that we can use to resolve inheritance disputes, which aids or resolves them. Inheritance disputes are not merely legal questions. And we need to think ourselves, they are not just legal questions, because they are deeply personal and cultural matters that touch on the very core of our family and community life. You cannot have inheritance disputes without family relationships. You cannot have you can have a dispute between one partner and another partner, but that cannot be an inheritance dispute. So we are linking, we are listing ourselves those disputes that concern people of the same family. So if we are going to think about how to resolve them, we must think in the same way how family relationships start. And I think I'll give an example. In Gikuyu, which is the one you people are used to, you know that if your mother was a wife of the deceased, you are entitled to, oh, you don't know that? You are entitled to inherit. If your mother was a wife, but if your mother was not a wife, and you know your mother might not be a wife, but it's still your mother, and you are indeed your father, you are indeed fathered by someone, but you are not fathered by the wife of a deceased, you did not inherit. What am I saying? I'm saying this. If your mother was a wife of the deceased, you are on the line of inheritors. If your mother was not a wife of the deceased, you are not part of that family. You are go and inherit in another family, if at all. That concept is difficult to put in legislation. And that concept has been challenged several times within our law, because you see somebody comes up and says, oh, I am entitled to this family, and I want to refer to a family which was recently, it still is, engaged in a tussle like that. Can one suggest whose family I'm talking about? You people are not living in Kenya. Sorry? Exactly. Moi Kibaki's some sons, I think son and daughter now, have resurfaced, and they say they were entitled to inheritance in his estate. And because that matter is in court, perhaps it's prejudice, I should not, sub judice, I shouldn't talk about it. But it is important to talk about it when we are thinking about what inheritance means. Because those children, that man, I think he's 45 years old or something like that, even if he is biologically the son of Moi Kibaki, in Kikuyu customary inheritance rules, he would not be entitled to inherit. Because you don't inherit by virtue of the deceased being your father. You inherit by virtue of your mother being the wife of the deceased. If your mother was not the wife of the deceased, then obviously you would not be entitled to inheritance. And I want, as we go on with inheritance, to keep those things in mind, because inheritance is not the same as succession. Right? Rules of inheritance evolve from a community. The rules of inheritance evolve in a community, but succession is rules that are made by an authority like Parliament to regulate inheritance. Are we together? You understand the concept? Because if you don't understand the concept, then a lot of what I'm saying will not make sense. Our succession law was introduced in this country by people who understand inheritance at all, who saw inheritance as being succession, and quite understandably, because he was not a native Israelite. He was a foreigner, and he came with that foreign mentality. We can unify all the succession rules of all the African communities. Can someone tell me who that was? Umesoma jana au kumekuwaje? Sorry? Yes, he's a judge. In fact, he was a judge in our court. Remember that. He attempted unification of two sets of personal laws. Succession, Ed? Yeah, retired. Sorry? Marriage, yes. He wrote out a unification code for succession and a unification code for the law of marriages. And I say this now that he is not here and is away from this land with some regrets. I actually admired him and actually worked with him, and I actually one time traveled to Swaziland to deliver a paper on his behalf when he was refused authority to travel by the government of President Daniel Arap Moi. So I knew him personally quite well, and I debated some of these issues with him at the time because I thought the succession law that was being brought was short of a lot of circumstances, because it assumed that the communities here all have one uniform law to regulate inheritance and succession. And that assumption was completely wrong. It still is wrong. But we put on an act, and we crafted an act called the Law of Succession Act, and it was passed, but it faced difficulties in application, implementation. It had, in fact, to be implemented in phases as land became the only inheritable property that was being recognized. But is land the only inheritable property that exists? Hakuna mtu anataka kuoga kusema? Sorry? Now let's say you are Maasai in the Narok and Kajiado. Are you likely to have land as your inheritable property? Are you? What would be is likely to be your inheritable property? Livestock, right? And if you are in Turkana out there with 300 camels, what would be your inheritable property? That desert there? Sorry? It's the camels. Because that's the inheritable property in that place. If you are here in India, as we are, what's likely to be your inheritable property? Land, right? Kahari, yes. These are, now, the law of succession did not take that into account. It assumed inheritable property is uniform, which is understandable because in England, where Eugene Cotton came from, the land was not inheritable outside the family because it moved from one person. I'm Jewish. How did it get inherited? Now I will go away. Hey. Do you know entail? Do you know fee entail? Okay, now let me educate you. In England, land is held. It actually belongs to the crown, right? But the crown has given to certain lords, right? They are minas. And that mina moves from the what? It moves from one person to his who? Go on. First son. It cannot go to second son. It cannot go to a daughter. It goes to the first son, the head of that family, and it goes on and goes on. Even now, like Her Majesty Queen Elizabeth, when she passed on, she passed all the lands of hers to who? To King Charles. Because King Charles is the firstborn of her family, right? It's the same. It only went into tail. So Eugene Cotton wouldn't see any inheritable property other than that. He would not be able to see that you can have people living in Siaya whose inheritable property is not the fish in the lake. It's probably the boats that go around looking for fish. Right? It's not necessarily land because the land that is there is communally held. And land there and here was communally held until when? Sorry? Until adjudication. And when did adjudication happen in India? Let's put it there as 1958-59. Before 1958-59, all this land you see here was communally owned, and it was farmed communally. It was not capable of being inherited because it's not yours. Inheritance, as you know, can only relate to what is yours. And inheritance is about property. If you have no property, you cannot, there is nothing that people can inherit from you. Looking good is not inheritable. All right? Being a nice person is not inheritable. What is inheritable is the property you hold. All right? And before, now I've run out of my text. Before 1959, there was no inheritable here in India. But now, after 1959, land became inheritable because it was privatized. What is privatization? Although now you know only about privatization of corporations. Individualized. People became holders of those titles. And this is one of tragedy from which unending disputes sprang. I will move away from the text and explain what I mean. When this land was being privatized, i.e. demarcated, consolidated, those who are older enough will remember something about consolidation and demarcation. Your land, the land which belonged to you, your family, there and there and there, was and then it was asked who is. When that was happening, in the area that we call Murima area, sorry? Somebody just say the Murima district or counties, so that I know we are talking about the same. Nyeri is one, another one. Kirinyaga is another one. Muranga is another one. Ebu is another one. Meru is another one. Rakanidi is another one. Kiabu is another one. Now those areas, and for the purposes of this land issue, we will leave the Rakanidi and Meru aside. But the others that I've said were worked on towards the end of the 50s. And when that was happening, majority of the men were where? Sorry? Detentions? Else? Some in Manyani, yes. And others were where? Akina Muriogi. In the forest. Fine. That's quite right. And so when the land was being demarcated, most of the men were either forest or in detention. And those who were in detention were thought to be associated with what? With what? Mau Mau. And this is what you might not know. An order issued which said that when this land is being registered, it must not be registered in the names of people who are in detention or who are in the forest. And those people who were, those men, I remove the word people, men who were here or in Nyeri or in Muranga, those invariably in every case were the younger members of the family, because they were not old enough to go to the forest or old enough to go to be detained. The others, a small group, are those who were cooperators, who were headmen and chiefs and were on the side of the government, the colonial government. And those, of course, could get chunks of land because they would be the ones saying, this is our land, this is my family, and so on and so forth. These others, they would be written out in the names of those young sons. And when their older brothers came either from detention or from the forest, they just came and began using the land as they have always used it over the years, not knowing that it actually now has been registered and donated to their brother. Some were able to, when they came back, they asked their brothers, now what happened? They are told the land was registered in Mr. Kamau's name. And Kamau said, yes, it was. It's not mine. It's our land. In due time, we will share it. But there are some other Kamaus who are clever. They began asking, at whose land? Where? Read the title. Whose land is it? Well, don't say our land. There's no land of yours. This is my land. And that is one of the sources of these inheritance disputes in this part of the world. Because it stuns people to know that this family, the man, the patriarch, had 5 sons. The first son had no land. The second son had no land. The third son had no land. The fourth son had no land. The fifth son has 22 acres. Where do you think he got the 22 acres from? Is that not the land which was that? But he has a title which says the proprietor hereof is the indefatigable owner, proprietor, contained in this. And some judges, I will say that now in the presence of judges who will harass me, some judges actually took that as conclusive evidence that the man owns 22 acres and his brothers do not own any land. Now, of course, they are reading a statute. It's actually in the law. But you can't read that statute and apply it that way unless you also give up your mind as a donation for people to use. Because if your mind is operating, you would ask your question, this very legitimate question. This is ancestral land. It is not land that was purchased from anybody. It belonged to the father, and it in turn to the grandfather, and so on and so forth. If it's an ancestral land, how is it that number 1, number 2, number 3, number 4 didn't get in any land, but it jumped from your father to number 5? You would be entitled to ask that, and therefore you would unscrap and create what we call what? Huh? Say loudly. A constructive what? Trust. Another one said, now this land can't belong to you alone. It belongs to you and these other people. That's what we, or if that would end that particular dispute. But if you don't, and you go to, it comes to you in court, and you decide that the person who is entitled, whose name appears on the title, is the exclusive owner of the property, obviously that dispute is not ending. It is going to the Court of Appeal. And when it goes to the Court of Appeal, it tries to go to the Supreme Court, and they look for a clause in the Constitution which you take it there. They manufacture one called Article 45, I think, was some entitlement to property, and they go to the Supreme Court and so forth. And even after they have got there, it's still not ended. When they have got there, whatever the court will say, one person will say, okay, wait for me. And that's where you will hear that the person was found dead near his home. Nobody knows who killed him. But he is there and he was dead. Do you think it is earthquake which comes or strikes him? It's not an act of God. He's been killed by someone who is bitter about the outcome of that court case. So that's one reason disputes are not ending. Now, I've run out of my script, so I better go back to it. And I'm saying that in some communities, such as the pastoral communities I have told you, the inheritable property is what? Livestock. In some communities, inheritable property is land. In other communities, inheritable property might be such things like money, businesses. Okay. These Asian communities you see here, do you think they have land that they goes down? No. Now, they are now buying land, but the majority of them haven't yet bought the land. But they are still dying and inheritable property being inherited, which is money, which is jewelry, custom, and all those things. And as I said, if it's a Somali, he'll probably be camels and things like that. Now, we say that the premises, therefore, must be that the framework we use in their resolution must be one which enables reasonable and acceptable outcomes to emerge. And this is where I say litigation is not one of such. Litigation does not enable reasonable outcomes to emerge. Why? Anybody tell me why litigation does not allow that to come out? Because litigation must result in a win-lose situation, right? Because it must result in a win-lose situation, it means the dispute itself is not ended. Because the one who loses feels entitled to challenge that loss in another place, and so on and so forth. The framework presently used in resolving inheritance disputes is litigation. And the law applied therein is the Law of Succession Act. The Law of Succession Act is that law that we put up in 1981 and subsequently amended several times, which was supposed to apply uniformly. It started by applying specifically, then another minister would come and apply it to such section, then to another section, then to another community. The Muslims fought out of it because initially the law applied to them, but they went to parliament and fought, and they were excluded from it, so that their succession now follows Sharia law. These other communities didn't bother fighting for their own thing, largely because they did not understand what the law, or how the law applied them. So they stuck there. Now I will use, what shall I say? A man is sitting there, and this one, is it of us Luya? From the Luya community? Yes, there is one there. So now listen and forgive me as soon as I stop talking. Now, he's a lawyer, he has actually 4 wives. Although we know, only one. And we have got land as heritable property in Luya land. So when he closes his eyes, we have to find out who is going to take on this property. So where do we go to find that? Not to their home. We ran to court, right? And then the court says, okay, you are here. You, exactly, who are you? And you begin saying, you know me, I'm the wife of the deceased. To the wife of? I put on your marriage certificate. And they say, no, I don't have a marriage certificate. If you don't have a marriage certificate, you are not the wife of? Sorry? You are not the wife of that person, the deceased. So you can't inherit. And now, we are now caught in the mess that there is something else which must establish your entitlement to inheritable property. And that is your relationship with the deceased. And that relationship with the deceased, we have said, it is only establishable by a certificate called a marriage certificate. And how many married women have marriage certificates? It's like a quarter of the married women in Luyaland who have one thing called a marriage certificate. It's the same here. There are some here, but they are not as many as out there, because here they keep on insisting that we must go to church. We must go to church. You must take me to church. That has reduced the number of the ones who are, but the actual number is not reduced. It only exists, but it exists under the service. It's a bomb. It's something under the service, which creates a lot of disputes, because it is from those under the service that these children appearing in Kebaki's estate come from, right? So disputes are there. We have covered them by saying that to be able to inherit, you show me a marriage certificate. Marriage certificate does not exist, but a child exists. And that child can only be recognized if you use other methods. And because you don't have that, a dispute arises. Are we together? Are you following me? Good. I'm hoping that as you follow me, you also understand me. Because if you don't understand me, I will have difficulties. All right? An examination of the manner in which the act was enacted reveals its unsuitability for resolving inheritance disputes. I've actually told you how the act was enacted and how therefore it cannot be used to resolve those disputes. Prior to its enactment, as I think I also said that, each community had its own inheritance rules. The law of succession sets the rules of, unlike inheritance rules, the law of succession is actually an act of parliament which is designed or intended to regulate succession. And succession is passing on property from a person who has died to a person who is alive. That's what succession is. But because succession is not equal to inheritance, and because I was told to talk about inheritance, not succession, my presentation is dealing with inheritance. Are we together? If I had been told to talk about succession, then I would have used other terms. I would have looked for terms that apply to how inheritance, how passing on inheritance property is regulated. But now we are seeking to find out rules that would enable succession disputes to end. As presently enacted, it affects us as conflicts with the rules and principles of inheritance in various communities in Kenya, thereby causing a lot of pain and anguish. When, for instance, a family goes to court to seek resolution of an inheritance dispute, the family itself breaks into pieces. You go to, once you have sued, are you likely to remain as fond of each other as you were? And especially if you are doing it in our courts, where it will take 42 years to resolve. Do you see what I'm holding here? My friend, can you tell them what I'm holding?
This is the infamous dispute of the Koinange estate that has been running in court for many years, I think from 1981.
Mm-hmm. Yes, I had the misfortune of acting in this drama at one time between 1993 and 2003. But it is a good example of showing you how litigation cannot possibly resolve disputes. And that's not all, it breaks families. Because when I was in this drama, there were 19 there were 19 claimants, if you call them claimants. Now there are 12. These others have gone to be the land. They don't need any land anymore. But do you see the pain, the anguish that it has caused in those years? People are not talking to each other. People actually shoot each other, and they are prosecuted for murder in Nakuru, and cases are withdrawn, and so on. That is because the disputes have not been resolved. And so, this inheritance dispute result in family disputes. I don't know whether you see how family disputes are born out of inheritance disputes. Are we together? Yes. Do you see how inheritance disputes give rise to family disputes? Yes. So that now they themselves are not ending, but they are creating other disputes which are family in character. Right? I'm sure those of you who are practicing law have seen cases where mother and son are not talking, or sister and brother are not talking. They go to court, they go in they board the same. When one family boards this matatu, the others can't go into it. Although it has seats, they have to wait for, and then to wait for the next matatu, and they are going to Krowea court. But they will not enter into that. And do you think when they come back from Krowea court, they are talking? No, they are not. They've completely been broken by inheritance disputes. So, if if you use litigation, you are not going to resolve inheritance disputes. I doubt also that you will be able to resolve family disputes, but we are not concerned with family disputes at the moment. We are concerned with inheritance disputes. But my topic then questioned the place of ADR. And now I stop from being a lecturer, being the one talking, and I ask you to talk. What is ADR? Say loudly. Alternative dispute? Alternative to what? Sorry? To litigation. Okay? If it's alternative to litigation, then it means litigation is out. Litigation does not resolve disputes, and therefore we leave it out and look for others which are alternative to it. And which are they? What does the Constitution tell us? Sorry? And traditional methods of resolving disputes. Now, we must look into that and see whether in that ADR there might be systems would resolve inheritance disputes effectively. Are we together? So if we can spend a few minutes just looking at them, starting with arbitration. What is arbitration? Sorry? Okay, it's a process involving what? A private judge. What's that private judge called? It's called what? It's called an arbitrator, right? And those who go to him or her are called what? No, they are not called parties. Parties go to the judge. And this is a private judge, therefore his parties are called what? See, I heard you people saying you are a fellow of the Chartered Institute of Arbitrators. Okay. One of them is called a complainant. Is it what? And the other one is called a respondent. Exactly. One is a complainant and the other one is a respondent. Now, those parties, did you hear? Are they family parties? Sorry? They must resort from and something. Sorry? Not a transaction.
Gigi, our case is going to be heard in the US.
What is that agreeing you are talking An arbitration clause which says any dispute arising in arbitration shall be resolved through arbitration. Right? It is not a family dispute. It can't be a family dispute. Right? So inheritance is not for arbitration. Correct? Because if inheritance is a family process, then it can't be for arbitration. Because in arbitration, it's only the judge which changes. All the other rules and regulations remain. The judge, instead of being paid by Kenya, instead of being paid by, what is his name? What the treasurer is called? What? The cabinet body. Instead of being paid by body, they are paid by you, parties. Right? That's all. But you go there with your evidence, you go there with your witnesses, and you do what that does. Therefore, it is not a method of resolving inheritance disputes that can be effective. All right, which was the other one? I'm avoiding going to mediation at the moment. Yeah? Conciliation. Now, what is conciliation? Now, conciliation is a process by somebody called a conciliator, right? And the conciliator sits and listens to who? To the parties. Ask the parties, what is the problem? And this party says the problem is this and this and this and this. And the next day he goes to this side. What is the problem? And he hears this side saying the problem is this. Then he sits down with his friends here and looks at those disputes and says, what do you think we can do? And then they formulate an answer. Once they have found an answer, they go back to this party. And they say, now, this dispute, the only way you can resolve it is this. Look. Do you agree? They say yes. Ah, good. Then they go to this other side and say, you do this matter, you can only solve it this way, this way, this way, this way. And they, do you agree? Yes. Then they come back here and say, now, this matter will be resolved as follows. A, B, C, D, blah, 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 blah. They give out the conciliation. Right? They settle the matter themselves. Not the parties. Are we together? And now we go to the third one, which is mediation. Now, mediation, and I've now completely run out of my script and just explain it. People come to a mediator, a disputant and another disputant. They say, now, Mr. So-and-so, mediate this, help us mediate this dispute. And then the mediator gets a table and a chair and some water and coffee and something here. And he says, we meet at Kilowea. No, this hotel is called what? Huh? So? Yeah, Roswani Hotel. On Friday at 10 o'clock. And he comes here and asks what you had done here. He organizes people to sit here. And then tells them, now you people, what is the problem? Tell your friend what the problem is. And you tell your friend what the problem is. And sit and agree. What you agree with is what we will record. And this, they talk. In mediation, we say that the cardinal rule of mediation is face-to-face talking without interruption about the problem, without interruption, long enough to find a solution. So you face to face, you ask each other, now what is this? How can we live like this and like that? Once you have agreed, that person called the mediator or the neutral third party then says, this is what I hear you people have agreed. 1, 2, 3, 4. Is that what you have agreed? Yes. Is that what you have agreed? Now, sign here. You get a thing, you sign, and you sign here. And the matter is closed. That dispute is actually ended. Why do I say it is ended? Tell me. Madam? Because it is their own decision. And they are doing it voluntarily. They are not being brought by judicially mandated mediation. They are doing it voluntarily. And they have found the answer. And if I may ask a question, who caused the dispute? Themselves. It didn't fall from heaven. It's not like lightning. It is from them. And now they have agreed how to resolve it. And is that not the end? And what we are trying to formulate now is that we must be able, because we are Kenyans, I think I must restate that, because mediation wasn't intended to have needed the court to do what we are asking them to do. Mediation was a voluntary process, and you agreed and you shook us. And negligence is his body. And the matter is ended. But then came some people called Kenyans. And today they will say this, and tomorrow they never said it. They are not even applying to set aside, they are saying they never said it. So we have said now, mediation should be, first of all, should be written. Right? And when it is written, it should be signed by both sides and the mediator. And that is the mediation agreement which the courts are willing now to receive and put force to it. In other words, say, this has now become a judgment of the court, and it can be enforced using the rules of enforcement that we use for judgments. Are we together? Corner there, are we together? Okay, if we are together now, I stop talking and ask you to ask me questions. Any question? Yes. Oh, okay. Discuss then. Yes. Before they ask the question. Yes. Yeah, so tell us what have been said. What have I educated them?
Yeah, allow me to stand here.
Yes, stand there.
Now that I am young. Good afternoon. Hasn't that been enlightening of us, isn't it? Actually getting to know the dichotomy and difference between succession and inheritance. We learn new things every day. I'll see you. So Judge, thank you very much. Your paper, I have read it. I can say with a lot of confidence and conviction that you are on point. And it is on that basis that you have laid a very good ground for me to discuss the paper in support of the same. The principal judge, Judge Mureithi, ELC Judge Mutungi, our chief guest, chair of Kirinyaga Bar, my esteemed colleagues, ladies and gentlemen, good afternoon. It's my singular pleasure to stand before you and discuss a paper by the eminent judge who has truly done justice to it. I must say from the onset that he has actually made me to change a bit of my presentation because I thought I had the benefit of knowledge of the current and the very recent affairs, but he has proved me wrong by this case of the Mbiu Koinange case. It was one of my case studies of a success story, but just reading the article, and the article is as fresh as 30th June 2025. They are back in court. It was one of my presentations under the success of mediation. But nevertheless, allow me to start from very heavy words that have been used by the eminent judge, on whose shoulders I will stand on to lay my basis. The good judge posits that the law of succession sets out rules to govern the process, while the rules of inheritance establish who such persons are. He goes ahead and says, the law of succession is enacted by the state through parliament, while the rules of inheritance evolve from each society and community. And I think that has been the biggest problem with litigation in aspects of inheritance, because the Kirinyaga community is different from the Bulembe community, the Jaluo community from the Mombasa community, and they go before a judge who is well learned and trained in law to apply the law as it is. What would you expect the outcome would be? Who lies with the laws and the norms of our society and our community? Is it the seat of justice in the courts, or is it the forefathers and our elders in the community? Why shouldn't these disputes be resolved through AJS, through ADR, whereby our elders sit under a tree and with their wisdom of knowledge, they are able to determine what are the rules of inheritance. Remember, inheritance, not succession. The good judge further goes deeper and says, when, for instance, a family goes to court to seek resolution of an inheritance dispute, the family itself breaks into pieces. The Mbiu Koinange family, 1981, many of us here were not yet even born, and still in court. 30 billion Kenya shillings. The lawyers also hamjachelewa. You have your stake there. You are claiming 500 million in legal fees. Ipo siku. Whatever the outcome of litigation, the family stands divided. Look at the families. The judgment brings to an end the unity that they previously enjoyed. He further posits, litigation by its very nature cannot and does not resolve any dispute. Hapo kuko na key, wacha nirudie. Litigation by its very nature cannot and does not resolve any dispute. It is not designed to do so. Litigation is designed to determine the rights and interests of the parties according to the law. The judge or magistrate is unconcerned with the emotional involvement of the parties. When we are talking about inheritance and family dispute, what are we talking about? We are basically talking about the emotions. You are speaking into the emotions of the family. When you rule by the stroke of a pen and the law, what do you do to this family? The last that I want to quote from his paper is, hence the dispute is not resolved. Where the dispute is an inheritance dispute, the family is forever torn apart and divided, and the family relationship is lost. And it is on those shoulders that I stand. I also want to quote what this article that the judge has come with. And this is what Justice, the CJ, Mother, she then was in January 2005 when she handled the case. This is what she said. I am sorry to state that going through the court file and the tactics employed by the parties and their advocates, the case can only be likened to a classical theater of the absurd. That is what the CJ summarized the issues before the court as. So what are we saying? The judge has submitted very heavily about mediation as the most preferred mode of resolving these disputes. I want to just highlight in brief the advantages of ADR and concentrating on mediation, and then I will highlight in way of demonstration of the benefits and the fruits of mediation. 3 cases. Of course, one of them is the Koinange case that I will still highlight how mediation has helped. So what are the advantages of mediation? The first one is it's cost effective. So to the family, they are going to endure less expense. Litigation is very costly. Hiring you, the lawyers, is very costly, and everything that comes with litigation. The second one, and important, is party autonomy. One thing that we treasure in ADR world is party autonomy. The power of the party to determine their destiny on their own. When you file matters before the judge, you do not determine that he will actually take it to the end. He will be transferred, it will go to somebody else. You just file and you wait for the court to do its thing. In ADR, you get to choose the mediator, the arbitrator, or the third party neutral who is to sit. That is very, very important. Party autonomy also involves voluntary nature, that it is on your own volition that you have submitted to that ADR mechanism. The third advantage is time efficiency. The story of backlog of cases has been sung and sung again, and I can go no further than just quote the Mbiu Koinange estate case that is now on its 44th year. ADR, when you get the service of that mediator, that arbitrator, he will dedicate back-to-back days and ensure that it is resolved in a time-efficient manner. The other advantage that is there in ADR, and we're happy that this is slowly gaining track and even coming into legislation soon, is the limited options of appeal. That once a settlement agreement has been penned down and signed by the parties, then it is fait accompli. You can only set aside that if you can prove there was any and procedural aspects. There's a case by Justice Joel Ngugi, as he then was in High Court Nakuru, that ring-fenced very well the aspect, the importance and the sacrosanctity of settlement agreements. And why do we say this? Even the mediation rules provide for this. This is basically because the resolution or the agreement that has come, it is not a decision of the mediator. It is the parties who have driven and has reached that decision. It is more of a consent that you file and it is adopted. Getting away from that consent becomes very difficult, and you must prove some procedural aspects. The fourth one is confidentiality. We do this in the confines of our chambers and in boardrooms, and your dispute will be resolved in a very private manner outside the eye of the public. The next is flexibility. Very, very flexible in ADR. And I want to give an example of an AJS case that was there in Kajiado, at Kajiado ELC. Kajiado is one of our best implementing counties of the AJS. And there was a case that had been pending in court from 1994, about 30 years. And it was a case of somebody had a title, just wanted to evict somebody who was allegedly sitting on their land. So it's an open shut case, isn't it? You have the title, indefeasibility of title, just take it, push through the case, and you have your order. But this man did not prosecute. The instructions to counsel was, do not prosecute this matter. Just let it delay and delay. Why? Because deep in him, he was claiming for 100 acres in Maasai land. Deep in him, he knew that the woman that he wanted to evict, the old woman he wanted to evict in the land, was actually the owner of the land. But in him, alikuwa na kero yake pia. His brother, a brother from another polygamous family, had taken 50 of his acres, which is adjacent. But he was a powerful man in politics and power and stature, and he could not ask him anything. So when the matter came up for hearing in Kajiado, I think before Justice Gisheru referred it to AJS, and in AJS, the flexibility manner, when he came, and the good thing with the Ma community, they respect their norms very much. So when they were convened for an AJS, they presented themselves, and he explained, and he told them, I have not prosecuted this case for 30 years, because I know if I do and I will win this case, myself and 4 of my generations will get a curse, because this is not my land. And that is why I have stalled this matter. And then he said, besides that, I have an issue. I have a brother who has taken my 50-acre land, and hiyo ndio kero yangu. You see, that matter of the brother was not in court. If it was court, he would have been told and join the parties, do a lot of procedures, and what AJS did, oh, you have somebody else, bring them. He was summoned, and he actually came. And when he came, they sat down, discussed it, and there was an amicable settlement. The 100 acres were given back to the old lady. The old lady, in the meanwhile, for those 30 years, his sons could not even marry, because umasaini bila shamba wewe ni nani? Nani atakukubali? So there was so much injustice that has been done to that old lady for 30 years, but through AJS, it was able to resolve. It was flexible enough to accommodate another dispute that came that was not in court, and the brother returned the 50 acres, he returned the 100 acres, and everyone walked home happy. It was a big day during the determination. The governor of Kajiado was called, our chair, Justice Joel Ngugi, was also called. And that is just one of the ways of showing how flexibility and accommodative AJS in action is. The other advantage is, of course, the win-win outcomes. Everybody in that situation walked home happy, and they lived happily thereafter, and restoring the family relations. Allow me to go to the case studies. And one common thing about these case studies, and I'll look at the Kanyotu case, I'll look at the Mbiu Koinange estate, and the Njenga Karume estate. All these are billionaires in their own right, but the families have never had the real fruits of the estates in this. And one common thing that you will find, I have just noted, and I will do my further research on that, about the Kibaki family. I did not know that there is also to be added here. So I will also look at that and add it. But one common thing that runs across this, and this with a light touch, to those of us who say one beautiful wife, is that they are polygamous. All of them are polygamous. So I don't know what that says, that we should do something or not. But anyway, all of them are polygamous. All of them are billions estate, starting with the Kanyotu estate. The Kanyotu estate is worth 15 billion, has 3 widows and many children. The dispute, again, we said our disputes are always about land. Land about 232 acres in Naivasha, and the shares at Kamutu Limited. So in 2014, the court case revealed there were fraud by administrators in the family, and in 2013, mediation helped to reach a settlement and to avoid auction due to unpaid rates. I have just seen in this article that the Koinange estate now has land rates of 40 million and land rent of 60 million, 100 million, and that is why Nairobi City County now wants to auction one of their property. So in the Kanyotu case, mediation helped partially to settle some of the issues. The good thing about mediation is that even if it will not resolve entirely all the disputes, at least when you have a partial agreement, you will have identified all the issues, and these are the ones that the parties have agreed, and these are the ones that are still outstanding. So even if, as it comes back to court, it has a narrow aspect whereby the court will only be looking at what is outstanding. I'm aware that I also saw, I think last month in the media, the Kanyotu family, they have finally decided that mawakili mumekula hii estate sana, na wakasema itoshe, wakasema wanataka sasa kuresolve through mediation. So mawakili, poleni sana. I know some of you are beneficiaries here, lakini Yesu ni Bwana, au sio? The second case is about the Mbiu Koinange. The Mbiu Koinange is case number 527 of 1981. 30 billion estate. 34 billion, and still growing. Today, they want to be auctioned because of 100 million rates by the county. It is also polygamous family, and across the judiciary, this is a family that has over 50 cases from different nature, of course all focusing on the estate. Na tusisahau pia ile yetu ya mawakili ya 500 million iko hapo ndani. So we also have a stake in it. However, when they were referred to mediation, some times back, I think by Justice Muchelule then, they were able to resolve some disputes, especially to the closed-ban estate, and partial settlements were done. So the focus now, I've just seen this, now that there is a dispute, two of the widows have now ganged up together against one, and they are claiming that that one has been eating money from this rental property, na alipi rates, alipi anything. Now that is the case before Justice Ogola, and I think he made a determination and said, actually part of the estate had been transferred to the unclaimed assets. Can you imagine? Mumepigana mpaka imeenda to unclaimed assets. So Justice Ogola added, also ordered that that money be released in a joint account with the family, and the first thing to be done with that money is clearance of all the liabilities. So it is still ongoing, but at some point, these partial agreements, especially to the closed-ban estate, really helped in resolving the dispute and appointing at least a structured way. They moved, I think, from 18 claimants to 12 beneficiaries. The next case study is about the Jenga Karume. Again, polygamous. Dispute arose among the children and the trustees, of course, when he died in 2012. In 2019, Justice Lydia Chode directed the parties to go for mediation. Mediation was successful, partially, and it clearly identified the beneficiaries and at least identified even the people who are to, in the interim, manage the business empires. And that is why, at least with the Karume enterprise, you can see that there is good progress to the same. So those are the cases that I can highlight. And
there was one of the two mediators.
Oh, Makofi to judge. Thank you. Thank you very much. Indeed, your wisdom must have prevailed. Was it fully settled?
Yes, it is actually. The properties are not the issue that we are now in the process of being.
Okay. Great. So that is the benefit of mediation. And as Judge has ably stated, there are various ADR mechanisms, but which is the most appropriate? We submit, and I support the paper and the presentation by Judge, that indeed mediation is the most suited. It is the most appropriate for resolution of these inheritance disputes. I finally want to share a few statistics. Knowing that we are lawyers, we ask ourselves sometimes whether a mediation, whether ADR is accelerated decline of revenue. I want to dissuade you away from that, and I want to convince you that indeed it is the appropriate dispute resolution. Globally, 70 to 80% succession cases are resolved outside the courts, and their success rates is above 90%. The court annexed mediation, looking at the SOJA report 2023-24, the court annexed mediation referred 4,708 cases. Out of those, 4,450 cases were successfully resolved. Again, over 90% resolution. The value of the said referrals was 33.7 billion, and what was released back to the economy is 8.6 billion. The SOJA report of last year puts the backlog of cases in the judiciary at 649,310. In 2017, under the CJ Mutunga, there was a justice needs survey that was conducted, and it revealed whooping and shocking statistics that started all this advocacy and push for ADR. That only 21% of cases or disputes in this country go to the courts. If you'll remember, there's a time that CJ Mutunga was opening a court in Kiambu, and he encouraged people, and he said, even if it will have to take you to Mganga and the witch doctors to resolve your disputes, kindly proceed. Go and resolve them out there. Why? Because, again, CJ, one of the celebrated CJs in this country, came from out and was not in the system, so he could not understand what is this backlog about. Hired judges, doubled the number of magistrates and all that, but the question of backlog kept on rearing its head until the research was done, and 79% of disputes were confirmed to be resolved outside the courts. Colleagues, I want to submit to you, if you want to live by the 21% and leave the 79% outside there, to those of us who are in this area, woe unto you. Let me also demystify the 21% and bring it to 4%. Out of the 21%, 17% are dragged to court. 17% are those that are taken to court either as defendants, respondents, or otherwise. It leaves only 4%, or accused persons in criminal. It leaves only 4% that a client walks to your chambers, gives you their story, and you move to court. Colleagues, you are only dining on 4%. Are you concerned about the 79%? I invite you to be very, very concerned. There was also a shocking revelation that 19% of Kenyans with issues, legal issues, do not take any steps whatsoever. They have lost either they cannot afford, they have lost confidence in any of the mechanisms, and it must concern us as ministers of justice. Hao ni wale wanasema umenikosea, lakini Mungu amekuona na nimekuachia Mungu. So ladies and gentlemen, I want to invite you to the 79%. I call myself a dispute resolution expert. When a client comes to my office, I will open the multi-door system to them and evaluate which model will be appropriate to resolve the dispute that he has come with. Because, and every day, when I walk to my office, I always look at those files and I see the human face behind them. These clients, when they come to your office, it is not out of will. Ni kero wako nayo. So ask yourself every day, what are you doing to resolve the conflict, the dispute that this client came with? If you find that the dispute can be resolved by mediation within a week, within 2 weeks, if you find it can be resolved by arbitration, by AJS, or any other alternative, I will so recommend. Does that take away my legal fee? Hell not, because my legal fee is earned at instruction. If the brief was to be charged 500,000 and I end up resolving the matter in 2 months, the legal fee is fully earned. And our brothers and sisters in the judiciary, they know this. So if I take my bill of cost there, if at all I need to, it will be enforced. What does that do? It does 2 things. The turnover of cases being fast, because that client came to you with a problem. If you resolve that problem, I promise you that client will come back to you. I promise you that client will refer more people to you. Why? Because he came to you, alienda hospitali, akatibiwa na akarudi nyumbani. Ukienda hospitali utataka kukaa huko miaka 5 ukimweka kotini. So look at those files with a human face and every day ask yourself, how can I unlock this problem? How can I resolve this case so that we can move forward? The other stream that you can have, so you have already secured your instruction fees. The question of bread and butter has always been, when we were rolling this out in 2018 and I was the chair of the ADR committee, it was a big, big issue that lawyers saw that we were slicing away their bread and butter. I'm telling you, we are not slicing any bread and butter. If anything, we are giving you peanut butter and jam. Muongeze kwa hiyo butter mko nayo. The other thing is train, upskill. Very, very important in this practice. COVID taught us one very heavy lesson as lawyers. When COVID hit, which government agency was the first to shut down? It was the judiciary, isn't it? COVID was announced on a Thursday. Next Tuesday, CJ Emeritus Maraga was on the stairs and announced the closure of courts. It was doomsday for the lawyers, isn't it? Si tuliona kivumbi mchana? Because basically, this is where ndio shamba yetu. And we get our fees. Kenyans are Kenyans. We get our fees. Unakumbuka kesi yako ni next week, kuna ile balance, utalipa, na analipa, na ukuje pia na attendance. And they will do that, isn't it? Now we could not tell them anything. Unajaribu kuitisha, mwezi ya kwanza ikaenda, ya pili tukajaribu ku-collect wapi. It was a tough time, isn't it? But the clients realized, Allah, this was our only hope to resolve this dispute. And now it has closed down. Where next? What next? So for us in the ADR world, we were actually smiling all the way. Because these traders, these merchants realized they need to move on with their life. And they came to us for dispute resolution. And online dispute resolution. Even before the judiciary took up the virtual courts, we were doing online dispute resolution through mediation, arbitration, and the rest. So I will urge you, my colleagues, upskill, get these trainings of mediation, arbitration, because it is an extra stream of income to you. I hope with those statistics, I have been able to convince you very well that it is indeed the appropriate dispute resolution, and especially for the inheritance cases. You have had inheritance. There are no rules of inheritance for the Gikuyu, for the Ameru, for the Jaluo, for the Luya. They reign within the communities. They ought not to be in court. In conclusion, Joseph Greenbaum said, an ounce of mediation is worth a pound of arbitration and a ton of litigation. Another statement, 10% of conflicts is due to difference in opinion and 90% is wrong voice tone. If only we can know how to communicate and talk, we can resolve a lot of disputes. Your worst battle is between what you know and what you feel. Mediation does not look at the rights, it looks at the needs, the underlying issues, the positions of the parties, and we try to align them. Mediation helps families find solutions with dignity and respect. The former president of US, Abraham Lincoln, a colleague, stated this as I finally drop the mic. Discourage litigation. Persuade your neighbors to compromise whenever you can. Ladies and gentlemen, I thank you very much for listening to me. I submit and support the paper by the judge. I thank you.
Thank you so much. At this particular point, I know we've been seated for a while. I would request Honorable Ireri just to give us something to stretch a bit, then we can start the prayer.
To appreciate also, okay, then Honorable Ireri, let's appreciate our speakers, and then Honorable Manura will give us a straight up a briefer, and then we can go to the plenary.
Now, we'll divide ourselves this side and that side. So I want this side to sit. We'll sing, I will make you fishers of men. So fishers and then of men this side. Yeah. So we'll start with the fishers of, I will make you fishers of men. Aya, tukai chini. This side sit down. This side will stand and we start. I will make you fishers of fishers. Fishers. I will make you of men. Mumeamuka. Asante.
Sorry. Thank you, Judge, and colleague Mr. Njuguna for the presentation. I think Justice Murithi, I think we need maybe Andy for the ins of the court. I think there's much to discuss. So I'm looking at Justice MUTHOGA na nafikiri tumpatie maua So I'm proposing that tuwapatie maua, and I think tutasimama tu ndio tuwapatie maua vizuri. Yeah, so so tuchukue wapi? Tuchune. Ya Karagani. Aya, tuchune ya yellow, ya pink, ma black. Sasa tuchune tafadhali, tuchune, tubagushie, tuchune tena, tuangushie. Ya mwisho tafadhali, tuchune. Asante sana.
Thank you so much. Now we are opening the plenary. The presentations were good, but then when the judge asked who are lawyers, I remember there's a silent custom where I come from. For the men, the more you get financially empowered, the more you add BB. So I was stuck there and I don't know what message I'll send to my people, because the empowerment lazima tuhudumiwe. So asante sana. We'll begin the plenary. I'll go per. What you'll do is you'll tell us your name and then you ask the question. So I'll begin with the people sitting on my, do I do left or do I do right? On this side. If you have any questions, raise your hand. And the rapporteur will be writing the questions and also inform us who you are directing the question to. Tafadhali.
This is in the evening. Good evening, everyone. My name is Onkundi Arati from the office of the ODPP. My question goes to Mr. David. You had indicated you are an expert in resolution of disputes. And from your analysis and study, you indicated mediation is doing so far well. And it's something you would recommend parties to embrace, including advocates. Now, some of the challenges that mediation faces is the complexity of emotions when parties are resolving disputes. So, in the course of you trying to help parties resolve their dispute, how do you handle the issue of emotions or the complexity of emotions amongst the parties? My second question is on the aspect of power imbalance. Sometimes you'd find parties are trying to resolve disputes in mediation, and you kind of feel one party has an upper hand or feels more powerful than the other. This can be by the weighing scale tilting to him or her, or based on financial resources or whatever aspect he or she is looking at, indicating that he has more power than the other party. So how do you strike a balance when you are faced with such a situation when it comes to resolving of disputes through mediation? Those are my two questions. Thank you. Onkundi Arati.
You know, when I have a mic, I have the right to speak. Judge MUTHOGA, I think just to get your perspective in regard to this, you spoke very well about the origin of most of the problems, particularly in this region, have to do with the demarcation and consolidation in 1958, 59, and 60. Yes, when our people came from the detention camps and the forest, and they found their younger brothers who are registered as the proprietors, it was all very nice. They didn't do very much. They stayed on. They were even shown where to build their homes and to cultivate. but they never went through the process of partitioning and getting their pieces. That generation of people died. The registered owner died. Of course, now the brother also died. Then the real problem that the courts in this region have is now the children or grandchildren of the registered owner, the ones who are arrived, they somehow manage to go through succession. They, of course, omit the other families, the other two families, and now you find when they get their titles, they actually even partition the land among their own house alone, leaving the other one or two houses. Now, of course, that is the genesis of the problem, because the other children, because they are also now children, not even the original brothers. When the matters crystallize, you find there is one party who are in the succession court, and now the other people now who are claiming entitlement, of course they can't go through succession because maybe the letters have issued and what have you. So you find there is one party of the family which comes now to the EROC court, because that is now a property dispute of ownership, and now there is a succession cause in the other court, and nobody is giving up. How do we try to navigate through that process? Because Judge Muredi will say, we have to wait now for the EROC court to sort out that dispute of ownership. And for the lawyers who are here, perhaps they might understand that the fact that a succession has taken place does not create a valid title to the beneficiaries, because trust is an overriding interest. And if the Environment and Land Court finds this land was held in trust, of course it will know even all those other things that have happened, because that is a trust land. Basically, those are the real problems here. The original owners died. In fact, even the second generation may have died, but now we have other generations who are the disputants.
And thank you very much, Judge MUTHOGA. If you could also give us your perspective on how to, we know we cannot compel people to go to arbitration, to mediation, because that will not be voluntary mediation. But we know the benefits of mediation, and parties are resistant or hesitant, or from their family connections, they cannot see eye to eye. How do we encourage, if not compel, them to go through mediation, or demonstrate some serious attempt at mediation before they come to pursue their interests? Second is that we send many files for mediation. We ask them to come and report in 60 days. And even after an agreement, partial or complete, has been filed, we still get people coming and seeking to set aside their mediations. So that the whole thing now is like mediation is just a step to litigation. You go to mediation, then you come back to mediation, to litigation. So it is more time spent out there while it will still end up back here. We want to see how we can tighten the screws to ensure that it becomes a meaningful, efficient, and effective way, an alternative to the court process. Pass it down the road.
Yes, I've just remembered another question, and it goes to both Justice Lee and David Njuguna. We've had a discussion, and we agree sometimes our culture does not really intersect well with the laws that we have. Now, we have two conflicting cultures, say from the Luya community and the Kikuyu community. Parties are before mediation. Is it something you faced, and how have you handled such disputes where parties are from different cultures which are conflicting and are before you for mediation? Thank you.
Any other question?
All right. My name is Jewel. I am a student, a law student in my final year. My question is addressed to the eminent judge, and it is that I am on this corner. My question is that how do you see succession law developing to a place that it considers the cyber world of online businesses and cryptocurrencies and, you know, what AI is generating? And especially as we consider how Mr. Njuguna just cited 79% of disputes not going to court. So then how does succession put this into consideration? The lack of a physical attribution to property.
Can I add on to that question? My name is Waithera, and I'm just wondering, Judge, they say hindsight is...
Sorry, Judge, my name is Jewel. Yes.
My name is Waithera. Judge, this is for you. I know you are a bit reserved about the unification of succession and inheritance laws, but I'm just wondering, was Eugene Cochrane a visionary? Do you think now that they say hindsight is 2020, that Eugene Cochrane was a visionary because he's united all these many communities under one law, and right now land is privatized, and as my colleague here says, there are other properties that were not even in existence at that time. You know that they are existing at the time, and we have digital real estate among other properties that were not there at that time. So maybe, your reservations about unification of succession law, are you rethinking it at this time?
It's another one here, Morigo.
Let me go first. As you've heard, Judge here is a trainer par excellence of mediation, and I would urge him also to share his views about the power imbalance and also managing emotions. But basically to Erati, the training of mediation gives skills, a subset of skills to the mediator to be able to tackle whatever comes in their way. The 40-hour mediation is very rigorous, and it is very hands-on, and the role plays that we do encourage in the training help to bring out some of the aspects. Power imbalance is one of them. Sitting as a mediator, you'll be faced with parties before you, and you can clearly see that there is a power imbalance. So there are skills that as a mediator, you are trained on how to handle this. And of course, one of them is, if need be, you may need to adjourn or call for a caucus, talk to the parties differently, just identify their strengths and weaknesses. And the essence is you need to help the weak party, but it should not be seen that you are helping them. So calling them to a private caucus, understanding their issues, and getting back to the position. And as the mediator, remember, you are again in charge of the process. So if there is somebody who is overbearing on the other, you have the power and mandate to keep them in control, just to give a fair attempt to both parties. Emotions, they do come out. And the good thing with emotions, we actually see it with serviettes there, because when emotions come, you pass it to them, they cry. And the good thing with letting emotions actually come to fever pitch is that when that person talks and talks, rants, vents, and talks it out, at the end of it all, they will say, you will get to see what is the underlying issues in the matter. There's a dispute, a succession dispute I resolved in Embu. 9 years pending in court between one family and Mama Mdogo. And Mama Mdogo was basically frustrating these others because they were not respecting him. And when they talked, they shouted at each other. As a mediator one of the virtues that you must have is that you must be very, very patient. You must sit there, listen to all the nonsense, listen to all the by stories, because within them, the position and the issues will come out. It ended up being, Mama Mdogo alikuwa anataka tu heshima. And we actually resolved the matter through an apology, and they shook hands after not seeing eye to eye in 9 years, and we resolved the matter. So it's just a technique that you get to learn once you are trained as a mediator. But there are very live chances that those do come on. I think the other question that was directed to me is about the cultures. Yes, the conflicting cultures. Yes, you can find the conflicting cultures. And actually such disputes, what I advise is they are better settled by AJS. Because AJS is whereby those cultures and experts in those cultures will sit. And if there's a multiplicity and they are converging, for example, in Kajiado, which is one of our best implementing counties in AJS, we have 9, the Ma community has 9 sub-tribes, so we have a panel for every sub-tribe. And then we know Kajiado has Kitengela, Rongai, Kajiado, which has a lot of cosmopolitan. So we have a cosmopolitan panel that basically listens to cross-cutting cultures and disputes around that. So there's still a way that such disputes can be resolved. I think those were the questions that were directed to me. I will ask Judge to take his. Thank you.
Could you take the one of
the crypto? Hey, Jiwel, umetuchanganya. Anyway, yes, the world is moving fast. The world is moving to digital. We are having now digital currency by kryptonite and all that. And we are moving from the traditional assets of land, and we are owning in a different manner. The question by Jewel was whether now the Succession Act does cater for this. And in the current days of AI, I think some of these laws we need to review them and bring them to speed with the current positions and the current realities. But by and large, cryptocurrency, digital ownership, that is asset, so it can still be catered in the current succession, but there is need for that reform to proactively consider that aspect. Thank you.
I'm not sure that I heard everybody. So if I don't answer your question, it's because I didn't. Maybe I heard it, but I didn't understand it. And you will excuse me and probably exemplify it so that I can understand it. The one I understood very well is one by Judge Muridi, which is how do we get people to agree to look away from the courts to mediation as a method of resolving their disputes. There is actually no single answer to that. But a series of things could be done, would improve it. One which I was not successful to do, I drafted a law, mediation law, and I got the judiciary, the Attorney General, and Parliament to agree to it, to accede to it. And it was finally read for the first time in the National Assembly. Unfortunately, the National Assembly had so many outstanding matters, I think 256 and enacted matters pending before it, when Uhuru came to relinquish office. And then they said, now all those matters which are running over from one generation to the other one, unless they have been read, the second reading will fall off. So the Mediation Act, Mediation Bill, 2019, I think it was 2019, died. I have not been able to find the energy to restart again. And I very much doubt that I have, because a lot of things have also changed. A lot of quacks have come in the mediation area, and they are muddying waters quite a bit. But it is necessary, I think, that the country as such enacts a law, a legislative structure for the performance of mediation. If we have that, it is one step towards getting people to look to mediation other than the courts for resolving of their disputes. The other one is those mediators that exist, my friend and others who are mediating, do so and do not allow something called lack of integrity to creep in. Because, you know, I think I can say this with courage, even if I'm stoned, it doesn't matter. One of the things that killed the reliability of litigation is corruption. I have practiced in the courts when you could count a single or at least two, possibly two judges who would take a bribe in the course of their work. Now I know that you can also count the one or two who don't. And that's the change in 2 to 3 decades. Now, if we can somehow keep mediation free from, or to be a profession of great integrity, will make people more come to mediation than to the courts. Of course, I re-emphasize that the mediator does not make the decision. It is the parties who make their decisions. But there are issues that come which require some decision or other of the mediator in guiding the process. And that is where integrity is required. And I think also that if we do that, the courts will become less and less attractive, because mediation can resolve disputes much faster, much cheaper, and the only thing it fails to give is if it suffers a default. That is to say, if it suffers someone to change his mind, you are unable to hold it. And that's why we are running to the court to seek authority to execute. But that will grow. And I think mediation will, in the end, become the way that Kenyans do. DCRI, Dispute and Conflict Resolution International, which I chair, one of its commitments, which is why I was going into the trouble of writing out a law for mediation, is to make Kenya change from relying on the courts to resolve disputes to getting them to rely on mediation. I have not quite succeeded. As I said, the law was killed, or not killed, the law was aborted in Parliament, and we have to try to sigh again and get it on. And two, I'm making every effort in talking and in training mediators to emphasize the need to think about the country, not just yourself or the parties before you. Then I was asked, I think that issue of power balancing is what every well-trained mediator knows how to do it. We have our nudges. We have the nudges which you use to get people across over an impasse, and also to manage the position where one person is obviously superior or higher or whatever it is than the other one. And like my friend said, you can go into caucus and do that, or you can talk down. Sometimes it takes talking down, because some people, especially in domestic mediation, matrimonial work, people come in feeling very, very, what shall I say, very high, very authoritative, and the poor women looked down, look at her, I have done this and done this and then done this for you. And you, as a mediator, take the position to get that person to see the falsity in that position. And usually it does. I have done one or two where people have come with egos that are bigger than this room, and I have managed to bring them down and see the realities. There's one I'm currently doing where I have not been very successful in bringing down the ego, but we are still on the journey. And I'm sure one day or sometime soon I'll be able to lift up the other party so they can talk on equal terms. Jiwa, tell me exactly what you asked. You wanted me to know.
My question was that in the wake of a world that does not really have the inheritable property in intangible form, but instead has it in cryptocurrency.
Oh, was yours a cryptocurrency?
Yes, it was.
That was dealt with by my friend. Okay, it is. Waidera, what was your case, your question?
She wanted to associate in her own words whether you think Kotran was a prophet.
Oh, wow. Yes. Judge Kotran, I told you he was my friend, so I did not despise him. I could see where he was coming from, because you have been contracted by the Kenyatta one government to write out customary law of succession. And the question is, do you say no, or do you attempt to do something? And I think he did not say no, he attempted to do something. And went around this country, blah, 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 picking or gathering the views of the people, and then put them into a document which was a code, and lied to himself and us that he had codified the customary laws. He hadn't, as a fact, and what comes out of it is what we are criticizing now, the law of succession. If he was still here, I would tell him, Judge, it didn't go as well as you thought it would be. But I told you I know where he came from, because he came from England with that English mentality that justice flows from the king downwards. And that then, if that is the case, you can dictate, because in his inherited property in his country was largely non-land, because land itself was not inheritable beyond the fee coming on. And that's it. I don't know whether I have satisfied you, maybe not. But
thank you, Judge. I think that's sufficient.
But is there, now that we are where we are, can we go back?
Can we go back? I would want to say I doubt it. And the reason is this. You see, we have now said we are one country. And anything that breaks that back into different counties, you can see how Gachagua is being beaten up for saying Mulima Mulima. Now, because we have said we are non-country, we couldn't do what the colonial government did, which is letting every community run its own inheritance properties, so that Mzugus inherited in their own way, Indians inherited in their own way, Muslims in their own way, and the rest of us in our own way, even if we went these marriages and something else and so forth. Can't do that now, because if we do that, we'll be saying the Constitution 2010 says we are one nation and we must remain one nation and so on and so forth. So I doubt that we can undo that. And now the inheritable property is the one that she is talking about. It's ceasing to be anything you can touch. It's crypto, whatever it is, and so forth. It's changing. And also, fundamental, like now, let me just take my own example. I have how many children? Nobody knows? Nobody? I have 4 children. Which gender? Female. Female gender. What that suggests is that they don't live in Nyeri. My local place of residence is Nyeri. Monyange. Now, one is married in the Ruolad, one is married in Kabalad, one is married in Meru, and the 4th one has yet to decide where to get married. Now, when I close my eyes, are they likely to come to Nyeri to cultivate tea? Huh? You think so? Very unlikely. So, and do you think the rat there will jump and go where they are? No. So, we will have to find another way of making that entity survive me, right? And it will survive me either because somebody will pick the rat and sell it and eat the money and forget it, or some brother of mine or somebody else will come and continue cultivating and so forth. I wouldn't be there anymore, I wouldn't need it, so I wouldn't be worried who has done that, but it will go on like that. And that's one example I'm giving. So a lot of people have, their roots are no longer where they came from, their roots are elsewhere, and therefore if you want to take them where they came from so that they can inherit, or the rules of inheritance can continue applying to them, you will have some difficulties. Good. Who else have I not answered? I think I've answered everybody. And by the way, I'm going back to Nairobi, so let us not go into the night.
Thank you very much, Judge.
If you want me to come again, I can always come again.
Okay, Judge. Okay. As we proceed, Judge came with some books. Judge MUTHOGA came with a book. There's a dummy over here, and they're being sold at the back there at 3,500. Judge Morevi has read a passage which I think most of us related to, and I'm actually interested to see the book and see what else is there, because I think all of us have gone through that phase. If you haven't, then you've missed out on life. So at this point, I'll ask just 3. I had said 5, but I'll lower them to 3 burning questions. Mr. Murigo had a question. Is there anyone else? Just 3 questions, burning. If they're not burning, then we can ask Judge the next time he comes. Is there anybody else? Okay, Mr. Murigo.
Yeah, I'm Murigo. My question can go to either the judge or Mr. Joroge, because it's an issue concerning mediation. It's a scenario where a mediator is appointed by court. He invites the parties. And once they are invited, they go into the session, and the mediator happens to bring some new parties who are not party to the suit which was referred to him. And they go to the extent of even writing a report and filing it in court. And by the time now the counsels who are on either side realizes The report is already before the court and the judge. And this is an issue where strangers have been brought now to benefit from the estate. So how do you treat such issues?
They're brought by
The mediator. You see, he invites the parties, which the parties have to come with their people. Maybe it is the parties who brought out the new members. Yes. Yes, and there is a mediator. Yeah.
The mediator introduces some
other parties.
He or she invites the village to come and discuss this, who are not parties in the party. With the consent of the parties?
No, now that is where the bone of contention was, because the the issue is that now the report has even been filed in court. Not yet. It has not been adopted, but it has been filed in court.
Going to mediation. But Mr. Murigo is asking about the live case. I think the less we say about it, the better.
But it is there.
There's nobody we have locked out. Any other questions will be as we had. So at this particular juncture, I thank all the participants for being active and engaging. Oh, those one? Okay.
One thing, and as I draw in also that concern, Judge, I want to bring news to you. Thanks to your effort in 2019 of jump-starting the journey of a mediation bill, in 2020 we had the appointment of the steering committee on the formulation of the ADR policy, of which I served under Senior Counsel John Uhaga. We sat in the COVID year 2020-2021. We completed our policy and submitted it to the AG. And last year, it was tabled in Parliament, in Cabinet and adopted. It is currently sessional paper number 4. In that sessional paper number 4, we have 3 bills. One of them is the dispute resolution bill. The other one is the arbitration amendment bill and the construction adjudication bill. Last week, if you saw, I was sharing the Chartered of Institute of Arbitrators public participation. It is currently under public participation. In the committee task force, we received a lot, over 600 feedback, and your organization, I remember, was one of them. So we are at public participation. If you have any concerns, just look at the bill and share your sentiments. In that bill, we are going to tackle such things. Currently, I know we have rogue mediators, but we do not have a clear stand on how to deal with them. Of course, the counter-next mediation and the CAM are there, But in the bill, we have proposed a disciplinary mechanism equal to LSK, and such things will be held to account. But I would urge further to that, that is a serious transgression by the mediator, and I would urge that you report him. And to say the least, I don't think, because in terms of adoption of settlement agreement, the parties come, the judge or the magistrate confirms with their IDs, they confirm that they signed the agreement, and once they confirm all of them in affirmation, that is when adoption happens. So I doubt that it will pass that threshold. Otherwise, thank you very much.
Yeah, but I can add that in that law, which is now going through public participation, reference to mediation is like a small section there, and it doesn't any good word. It is just there. It has segmented. Not even token. It's less than token. It has segmented arbitration and segmented conciliation and made a small reference to mediation. I was tempted to write for it the other 2 weeks ago, but I said, why am I wasting my energy on a matter like this? Let us go, because we will still need a Mediation Act. Even with that, we will still need a Mediation Act. And I probably go back to repersuading, now that we have a Chief Justice who is mediation oriented, if I may use that. I think I'll find it easier to get a proper, see, we must avoid the court controlling mediation, because it is not a judicial function. It doesn't make decisions. Courts make decisions. That's why they are courts. We don't want mediation brought into the court and put under the court. We want the court to continue doing what it does, to send the cases they are not able to do themselves to mediators, to help those getting resolved outside. But we need registration so that mediators who are actioning there can say, I have done it according to these rules or according to that rules, so that there is a good or a bad mediator. And I think that remains the way we would want to. I would want it to go about it. Countries like Ghana and others have done it that way of composite registrations between that, but they become so difficult to disentangle to make it understand. They lead you back to court. And anything that is leading you back to court is not helping you. Yeah.
Thank you very much. So at this point, I will be inviting Mr. Ngigi, our LSK chair, to just give a vote of thanks. Then we'll have the closing prayer by Mr. Mwangi Kinywa. But before that, Judge?
Before you do, so that you'll have to start, I'd like you to announce, if we don't know, that we have the manual, and then people can access it on judiciary site. Did you just read it?
Judge has, there's the Judiciary Court Annexed Mediation Practice and Procedure Manual. We can access it through the judiciary website. So if you want to look at it, there, you'll be able to read it. Asante, Judge. Yeah, together with the rules. Yes, and I know that there's a mediator's code of conduct that is usually with the mediators, because I'm the mediation DR. So in the event there's any such complaint, kindly let me know so that we can deal with it. Thank you. So, Mr. Ngigi.
Thank you, Madam DR. brief. I'll be very brief because my brief is very and straightforward. Vote of thanks. I want to thank the Almighty God for providing this day, and indeed it's a successful day. Can you clap for that particular, for the day? Was it not a good day? Let me start by saying thank you to our judge, Justice MUTHOGA, the judge in regard to ICTR, and now that they are winding up, is currently at International Video Mechanism for Criminal Tribunals. Thank the judge not only for attending today's meeting, but also for serving the membership of the Law Society. Understand even our judge was a people there. And during my time, a lawyer by the name Mugambi, I do not know whether he's still in the firm. Mugambi, he must now be very senior there. He's still in the firm. Thank you very much, Judge. Clap for the judge for that particular. Then for my brother here from Embu, Mr. Njoroge, we served with him in the Law Society for quite some time. And when I made the call, he quickly agreed to come. A clap for Mr. Njoroge. One clap for Dr. Wambogo. He never appeared, but also being on this particular paper is also a point. And it is on record that he was supposed to appear. I'll make a call to Dr. Wambogo. He was also my lecturer at Moi University, and I'm sure most of the young ones found him at Kenya School of Law. So this is a guy that I'll easily talk to. You know, of late we've been having discussion between students and teachers. It was a pupil of the judge, and probably the judge will tell him that is not what I taught you. Judge will ask that on my behalf because I can't ask my teacher that. I'm sure he was engaged somewhere else, but that is okay. We shall invite him again. And I'm sure that particular time, what they say in Uganda, he'll come and revenge and make sure that he attends. Also want to say thank you to our judge, presiding judge, Justice Mureithi, for coming up with this idea and for even allowing us to organize this. A clap for the judge. And our brother here, Justice Mutungi, I'm sure he called the senior to make it happen. We also have a date with him on Friday. So a clap for the judge. We have our CPD next week on Friday, 11th of July, and our chapter, Kerenyaka chapter, is hosting it, and we shall be having a topic on land administration and practice, and the judge will be one of the presenters. Thank you very much, Judge, in advance. Thank you very much, our JOs, led by our CM. I don't know whether she was taking notes or doing other stuff, but it's okay. She is still here. A clap for our CM. Other JOs, I can see my friend from Baricho. A clap for our brother. A clap for our sister from Wanguru. Somebody from Geshogo, she left. Or Manura from Geshogo. Waidira, our small claims court. I think I've covered everyone, all the courts. Have I left any? Sorry. Oh, this one is a bit special. She has done a lot, our facilitator. A clap for our DR for doing it. That was very nice. Other stakeholders, members of the Law Society of Kenya, a clap for yourselves. A clap for the council members present. Can you stand up, council members present? Council members, so that for facilitating this, council members. We have the secretary there, and our rep to the Mount Kenya branch. Yes, I'll get that, Judge. Thank you. A clap for them. Our office of the DPP. Thank you for being part of this business. Thank you very much. You also need mediation in whatever that you do. Our office of the CEA, County Attorney, and our SG, Solicitor General. Thank you very much. This is the Solicitor General, I believe. That is SG and the CA. Yes, they are big people, big ladies. And she's also part of the county government. A clap for her. Yes, the other providers or the support staff, starting with our rapporteurs, we have Sylvia. Lift your hand. She works with the farm of Magesh. She's very new, but part of us. Then we have Jacqueline, also our secretary. We have our other providers behind there. Those who are doing it, streaming it live, a clap for them. The one in charge of our photography there. I hope tutatoka vizuri kwa hizi picha. Otherwise. Then this is very important, Judge. We've had very nice sound. We've gotten it from Grado FM 104.6. You know, Judge, you've been looking for a local radio station.
Yes, and I have asked even Chief, I have asked to promote our locals.
Yes, and we have one which is based at Kagumo.
Yes.
Grado FM. Glado. G-L-A-D-O. Glado FM. Glado. Yes, that's like Glado. 104.6, when you go at home, just tune and you can have a feel of Keregoya. It has a radius of 100 kilometers. So we can do Thika, we can do almost beyond Nyeri. Yes. This is a side we can do beyond Chuka. Yes. And those advertisements that you always talk about, yes, when you want to do your meetings within the court, that is the best partner that you can work with.
And they can give us competitive rates?
Yes. Now that we've known each other, I think that will lay down the basis of future engagement. And whom I have, Nimashia Nani? And myself. And as I conclude, I want to award for my brother here. He's saying he's doing some case studies. He said, through our senior, he has been told about the Kibaki case. He should get another case, the Simeon Nyachae case. It's another case that needs some very serious studies. It's a matter where a widow has come up, and she is the family as a widow. Then I guess somebody in the family has brought another man in the matter, saying, "You are not married to Simeon Nyachae, you are married to me." So it's a matter that we need to study also. Yes. And the last one, as you proceed saying, the last case is the Kanyotu matter. You said that there were 3 widows. I was part of the first people who petitioned the matter. And that particular time, we had 7 ladies or women who said that they were widows to the late Kanyotu. We later were able to reduce them to 3 And you see, although I'm no longer in the matter, my client died. At the initial level, sometimes, at the initial level, the family was very broke. So they decided to make a decision by consent involving the 7 of them to sell some property because they were very broke. Yes, Kanyoti was a kind of a man who deal with, I'm running everything. I'm fueling your car. I'm paying for your rent. Just take this card, go to the supermarket. So you don't have to. When that man dies, then you can't move. That was the situation. And they agreed to sell some property by consent. And when my client was paid some millions, because the mother was deceased and was coming in place of the mother, my client was the alleged first widow. She had not even gone to school, and that's the one that Kanyotu had first married. When my client was paid some millions, anybody who would identify him in a bar, he could buy alcohol for the whole bar. Munajua Kanyotu he died as a result of that, and that is how I lost the client. So thank you very much, Judge. We shall be engaging you in future. Very serious issues to 1959, 1960 trust. That's an issue that we should engage in, probably in our next Inns of Court. Asanteni na Mungu ambariki. If you allow, you can have just one photo there, just for the memory. Judge, just 1 minute, if you allow.
Here or outside? Here.
Photography, unawapi ni pale nje? Yes. Asante. Prayer. Just do it wherever you are.
Bwana asifiwe. Na tuombe. Baba uliye juu mbinguni, tunakuja mbele zako jioni ya leo tukisema ni asante kwa mkutano. Kutoka tulipoanza, tukua katikati mpaka sasa tumefika tamati, tumeona mkono wako. Bwana uliye juu mbinguni, tumefika wakati wa kutawanyika. Kila mtu akirudi kwa nyumbani uwe na pia tukirudi magazini kwetu pia ukuwe nasi. Tunaomba haya machache tukiamini. And the grace and the fellowship of the Holy Spirit be with us now and forevermore. Amen.